I also started the recording and we'll get this front part cut off for you.
Okay, thanks.
All right, you can go ahead and get started, and people will join it as we continue.
Hi, I'm Christine, the seminar coordinator with the Federal Public Defender Office. Welcome to our first webinar. Today's program is about litigating compassionate release motions in federal court. There will be handout materials which I will send to you by email after the program, along with the program evaluation. Application has been made with the Ohio Supreme Court for 1 hour of general CLE. Once our application has been approved, I will submit the credits to the CLE Commission using the bar number you submitted when you registered for this event. Today's event will be presented to you by Kathy Shusky and Christian Grostic, research attorneys with our office. They have each had compassionate release motions granted in our district, and they will discuss the process in detail for you. There will be a question and answer session at the end of this program, but please use the question and answer button at the bottom of your screen to submit your questions along the way. We hope you enjoy the program.
Okay, good afternoon. So I'm going to start the discussion here about litigating motions for compassionate release. And this is the general agenda of what we'll be talking about. We're going to first talk about the CARES Act. The CARES Act does allow for home confinement, for the BOP to send an inmate home on home confinement to finish their sentence. But there's also the compassionate release statute. Those are different. Those are two different forms of relief. So we'll talk about those briefly. We'll also talk about the First Step Act that changed the compassionate release statute. We'll talk about what that change was and how that's affected what we're doing now today. We'll talk about the structure of a compassionate release motion, what needs to be in that motion. We'll then do a practical assessment. We'll tell you basically when we get a compassionate release motion, what is the process that we've been doing about evaluating, what kind of records do you need to get, what are the processes of going through once you get assigned a case. And then we'll finish up with some resources and some other important information that we think will be helpful to you. And then we'll make sure we answer any questions at the end if we don't answer them throughout the program. So the CARES Act versus compassionate release. I will tell you, I think every compassionate release client that I've had to date is confused about the two of these. And they're important, the distinctions are important because it affects the exhaustion requirement, it affects a number of things. So it's important to make sure that these two are kept separate. So the home confinement is permitted under the CARES Act. And so the CARES Act expanded what the BOP's requirements could be, the time of home confinement permitted from the BOP. So what was required was Attorney General Barr was supposed to make this finding that the emergency conditions materially affected the Bureau of Prisons. He did make that finding. He made that finding in his letters on March 26th and April 3rd. And I'm going to see if I can't get to, I want to show you. The thing about the home confinement CARES Act is that the BOP sets the criteria for this, and it is the BOP's authority alone to grant this. So if a client has been screened for home confinement under the CARES Act and been denied by the BOP, short of administrative appeals and helping them do that through the BOP, there's not much you can do about it. The BOP is supposed to be screening all inmates. Let's see if I can scroll down here. Inmates do not need to apply to be considered. I'll tell you that's not been my experience. Either each institution's kind of doing their own thing. Whether they're screening them all, I don't know. But a lot of the inmates are not getting informed that they have been screened. So I have been encouraging clients to submit a request specifically for home confinement under the CARES Act if I think it's helpful. What the criteria is supposed to be is a little bit fluid as well. You know, the BOP is supposed to be setting the criteria. The BOP says that they're referring to the Attorney General Barr's letters. The links to those letters are here. I'm pointing at my screen like you can see me, but the letters are here. And I would read those because I think those are important because the Attorney General Barr lays out priorities. There are very few conditions of eligibility in there. They're really just priorities. And I think that's helpful. And we'll talk about this here in a second, when rebutting some of the arguments that the government is making in their opposition to compassionate release. So criteria tend to be things like, you know, the big thing that I get clients denied for on this home confinement is their security level. So if they're at a USP, they're going to be denied. Their pattern score is below. I've had a client who was a low, which is a very good score. There is the minimum or minimal. And so if a client has a pattern score of low, I think that's an argument you can use to enhance your compassionate release motion, but that may get them denied on the home confinement under the CARES Act. They do need a reentry plan and all of that. We'll talk about that as far as the compassionate release, but that's also similar to the CARES Act, which again leads, I think, to some confusion. So the CARES Act, there's some resources here from the Federal Defender's webpage. I would encourage you to take a look at that. The CARES Act also made some other changes that we won't talk about because they don't really relate to the compassionate release, but they talk about proceedings that are available by video conference and now telephone. So those are available. You can sort of see a handout link there that talks about those other changes. So one of the things that the government I have seen make when I file a motion for compassionate release, their opposition tends to say something like, well, the client got denied home confinement under the CARES Act, therefore, for the same reasons, the court should deny the compassionate release. So for that reason, I set out this slide because there's plenty of criticisms about the way the BOP is handling the CARES Act. This is just a few links. If you Google it, there are tons more, and we'll get you some resources at the end too. So you might be, while you're not technically representing the client under the CARES Act, you might be forced to deal with why they were denied under the CARES Act. So the CARES Act does not preclude any compassionate release. So even if the BOP says to your client that he is eligible for home confinement under the CARES Act, I would encourage you to consider still pursuing the compassionate release. There's been some circumstances, I think towards the beginning, I don't know if they've been recently, where the BOP was changing their standards about whether they would release somebody under the CARES Act. And so I've heard stories about where a client was told they were eligible and would be released, so they didn't pursue a compassionate release. Then the BOP changed the standards for the home confinement under the CARES Act and then withdrew their approval. So then they had to start the compassionate release process. So I think you can do both at the same time. They're two separate avenues of relief. If they're released under the CARES Act and they go to home confinement, they are still under the jurisdiction of the BOP. So the court still has the authority to grant a compassionate release. It may undercut your arguments about why the client needs to be released if it's, you know, COVID related and they need to get home to get out of the institution for that reason. But there are other arguments about compassionate release that may not be undercut. So you just have to do that evaluation. So separate from the CARES Act is the compassionate release statute. And so while it is entirely within the discretion of the BOP to release somebody under the CARES Act to home confinement, it is within the court's prerogative to reduce a sentence under the compassionate release statute. So the court can reduce the sentence to time served, but they can also impose a term of probation or supervised release that is up to the remaining term of the unserved custodial time. So if the client has a year left, the court can reduce the time to time served and impose a supervised release condition of home confinement for that remainder of the year. It is my understanding, and this is just starting to sort out, is my understanding that that is in addition to the typical, not typical, but the already ordered, typically 3 years or whatever of supervised release. So that is in addition to that, is my understanding. But I haven't actually litigated that yet. So a compassionate release after the First Step Act. So prior to the First Step Act, only the BOP could move for compassionate release. The inmate had no authority under the statute to request such a relief. This change was made under the First Step Act. So now the defendant can move for a compassionate release after he's exhausted his administrative remedies or submitted the request to the warden and waited 30 days. This is the remaining part of that compassionate release statute. So after you've met the exhaustion requirement, the court may reduce the term of imprisonment if after the court considers the 3553A factors, if there are extraordinary and compelling reasons, or the defendant is over 70. We'll talk about that a little bit, but typically they're going to fall into the extraordinary and compelling reasons section. And then also if the reduction is consistent with the applicable policy statements under the sentencing guidelines. If you want to get a little bit more information about the changes from the First Step Act before and after, FAM has this great little flyer that details what it looked like before and what it came to look like now. Just to let you know, some of the First Step Act made those changes because I think Congress recognized that the BOP wasn't moving for compassionate release. I was looking for those stats. I've seen them, but I couldn't put my hands on them. They were small. The number of motions that the BOP put in for compassionate release prior to the First Step Act were very small. So the First Step Act expanded that authority. Now you'll see some stats here that saying they're still very small, and the BOP is opposing all of these. So at least in my experience, all of these. So there is a proposal by a couple senators out there under the COVID-19 Safer Detention Act to expand the compassionate release a little bit. You can see some more information there. It is still pending. I won't get into the details about what it might look like, but just be aware of it. So if it does pass, you'll have to update yourself on what that entails. So what is a typical structure of a compassionate release motion? It involves a description about the procedural requirement, the exhaustion requirement being met. You got to detail what the extraordinary and compelling reasons are. You got to discuss the 3553A factors, including that the defendant's no longer a danger to society. And you got to detail what the release plan is for when the client is released. The procedural requirements, I know some of the judges in our district now have taken the position that if the compassionate release motion does not explicitly lay out that the exhaustion requirement is met, they will dismiss it automatically without prejudice. So just be aware for clients that are filing these pro se and you might get assigned afterward, it might get kicked pretty quickly, but you should be able to file again, explaining the exhaustion requirements have been met. So we're going to talk about each of these individually here. We'll start with exhaustion. So the exhaustion requires the district court to consider a motion after the defendant is fully exhausted all administrative rights, or the lapse of 30 days after the client has, or after the warden has received the request from the client. So whichever is earlier. There were, or is, I guess, a split on exhaustion about whether that could be waived. We were litigating that for a little bit. The Sixth Circuit has spoken in the Allen case and said it cannot be waived. So at this point, the only remedy that you have is to file the request with the warden, wait the 30 days, and then file with the district court. Some of the clients are filing early. We get assigned after, and the exhaustion hasn't been met at the time. We usually are asking for a little bit of time to file the supplement. By the time the supplement is filed, hopefully we have met the exhaustion at that point. There was a little bit of a dispute for a while about whether if a warden denies a request within that 30 days, whether the inmate needs to pursue all the administrative appeals through the BOP before they can go to the district court. Read the Allen case to say they do not. So you should read that opinion carefully. You can cite that for that purpose. But I will tell you the government has taken the position pretty consistently that the inmate does not need to exhaust the administrative appeals before going to the court, which is good. And we'll talk about what those administrative appeals are just so that you're aware of them. I have been encouraging clients, probably less so now that the Allen case came out, but I do encourage clients to pursue the administrative appeals. I don't see how it hurts them. I think it could only help them. So the administrative appeal process is set out in this section of the CFR. It talks about, we'll talk about the request to the warden is on the BP9 form. If that gets denied, you got to submit the BP10 form to the region. And then if that gets denied, the BP11 form to general counsel. So the request to the warden, typically the inmate is going to submit that request. The inmate can submit that request on a BP9 form straight to their counselor. I know I've had some clients in some institutions that are able to do it electronically so that they have some sort of receipt. I will tell you, it's really important that the client is able to track when they submitted it and proof that they submitted it, because there have been cases where the BOP says they don't have a record of it, or we just can't establish proof that the exhaustion was met, and it gets kicked for that reason. The other option is you can submit a request to the warden on the client's behalf. I've done that straight. I've FedExed it to the BOP institution with a receipt, return receipt. I've also emailed it to the executive assistant, which his email address is found on the homepage of the BOP institution that you're sending it to. I mean, the slide says to copy the attorney for the facility. I don't. I tend to just submit it to the executive assistant email. I generally get a response back within a day or two that says it's been received and it's been forwarded to the appropriate department. So I keep that receipt as proof. So if you have a client that's in an institution where he says he submitted it but doesn't have proof of it, you might want to consider submitting one on his behalf or her behalf. So the request to the warden is going to look very similar to the request that you're going to submit to the court. It's going to contain really all of the same things. It is important, though, that this request to the warden is very clear that it is a request for compassionate release and not a request for a home confinement under the CARES Act. And this is where a lot of the clients are, I think, getting into trouble because they're submitting the request asking to be sent home on home confinement. And the BOP is taking that as a request for home confinement under the CARES Act. That is not going to satisfy the exhaustion requirement under the compassionate release section. Or it's possible that it's not. I mean, if the government makes the argument that that's not what they asked for, they didn't ask for compassionate release, it's possible that those two things are gonna end up causing you some problems on the exhaustion requirement. So just make it very clear to your client, or if you're submitting the request, that you're not asking for this under the CARES Act, that you're asking this for a request under the compassionate release statute. And again, just a quick note on the process here, right? So the BOP, you're not asking the BOP to, under compassionate release, to send you home, to send the client home. You're asking the BOP to file a motion for the court to grant compassionate release. So as I understand it, reading all the CFRs, the request goes to the warden reviews it. If the warden recommends compassionate release, the warden will put together the recommendation package to go to the regional director. The regional director will review it, make a recommendation, then that will go up to the general counsel. If the general counsel agrees, then they will get the government to file a motion for compassionate release in the district court. So that's sort of the process. It takes some time, although if you can get the government to file the motion for compassionate release, chances I think of it getting granted are better, right? So you want to include in this request to the warden the same as all the other things. You want to talk about the extraordinary and compelling reasons. What are the reasons justifying the reduction in the sentence? You want to address the release plan. You want to know where the client's going, and Kristen will talk about this too, where they're going to go, what they're going to do, how they're going to care for themselves. Just be aware too that the client needs, the extraordinary compelling reasons need to be consistent with what you're asking the court to do later. So I know there were some compassionate release requests submitted to the warden pre-COVID. And then when COVID hit, the exhaustion requirement had been met, so the compassionate release was filed with the court. The DOJ said, yeah, you haven't exhausted because you didn't raise COVID as an issue. So I don't know where that ended up, but it seems like the requests for compassionate release need to be similar with what the warden reviews. Okay, I think I'm gonna stop sharing and turn this over to Christian.
Right, so we're picking it up from there. There we are. So this was what Kathy laid out, right? The typical structure, and she started with the procedural requirements. So we're just going to keep going from there. As a framer, right? This is the statute, and so these are the things that have to be addressed, and that we're going to talk through. The first one being the extraordinary and compelling reasons. 3553A factors everybody's familiar with in some way. And we're going to dance in and out of the policy statement because they add one more requirement, but also fill in some of what extraordinary means. Extraordinary and compelling reasons. The guideline, sorry, and this is the guideline, right? Which adds the element, not a danger to the safety of any person or the community, but otherwise just repeats what the statute is. So the guideline has definitions for extraordinary and compelling reasons. I'm not going to read all of these because I know you can all read, but if you can fit your client into one of these categories, that's ideal, right? Because there's no dispute then that this is something that qualifies. Serious physical or medical condition is often what we're looking at, but don't ignore age either. The family circumstances one, you'll need to look at the guideline more closely. It really only involves if the client has children where nobody else is available to care for them, or a spouse who, because of terminal illness or something similar, needs the client to take care of them. Other family circumstances like, well, other family members, but you might be able to bring them in under other reasons in section D. Now, section D, and we have underlined there, right? It says as determined by the director of the Bureau of Prisons, there could be other extraordinary and compelling reasons. That obvious, well, not obviously, but stepping back, this policy statement was adopted back before the First Step Act, when the only way to get a compassionate release motion into court was through the Bureau of Prisons. Now that defendants can file on their own, the policy statement hasn't been updated. I think everybody's aware there is no quorum on the Sentencing Commission, so they can't amend the guidelines right now. They can't adopt a new policy statement. So this still says, as determined by the director of the Bureau of Prisons. The guideline actually still says that the motion has to be filed by the BOP. That's obviously not true either. So because of that, most district courts have held that the policy statement is no longer strictly the only grounds that they have to follow. A couple quotes there that are useful. Government filings that I've seen oftentimes still go through just the enumerated circumstances, these here, to say, you know, you don't fit A, you don't fit B, you don't fit C, you don't fit D. And, you know, our job is then to either fit them into A through C or to argue that D, right, isn't limited to grounds adopted by the BOP, and to explain why they're extraordinary and compelling here. Specifically, this is the one that we're seeing a lot of, right? COVID-19 plus something else. Two quotes there. The first one is from district court collecting a bunch of cases where they say, you know, dire prison conditions plus some significant underlying health condition. And we'll talk about that in 1 second. The health condition can be enough. The second one is actually from a government filing in the Supreme Court in the Elkton litigation, where they told the Supreme Court they are taking the position that if an inmate has a risk factor for COVID-19 identified by the CDC, that the DOJ's position is that that may be an extraordinary and compelling reason. So that's important to keep in mind. I'm not sure that that's filtered down to every AUSA yet. So every once in a while, I'm still seeing, I have seen at least 2 oppositions recently where the government agreed they were extraordinary and compelling because they had a CDC risk factor. But I've also seen some where I had to argue, no, this is a CDC risk factor. Now the CDC risk, that got complicated yesterday. So the CDC changed its website about how it identifies people at higher risk literally yesterday. It did some things that are helpful. It added more conditions than were on there previously. It did some things that are potentially hurtful. It used to just be, here's a list of people with these, and if they have these conditions, they are at higher likelihood for severe illness. Now the website says, we can actually go there, I think. Yeah, let's take a look. Now it breaks it into two groups. There are those at increased risk, which are those, we'll come back to that. And those are those that might be at increased risk. And might meaning the evidence is not as strong as in the first group. There's a link here, want to see the evidence behind these lists, and that's where they detail some of the, we can actually go there too. Some of the studies that support each of these. So you can see at the top, there's the strongest and most consistent evidence, mixed evidence, limited evidence, and then here are all the studies that are referenced. I'm not going to go through those, obviously. But the effect of what we have here then, right, is we have this list now that these are the strong evidence lists. These are people that are at risk, the CDC is saying. Again, I won't read it. But if your client fits one of these categories, I think we can still expect that the government will at least take the position that they may constitute extraordinary and compelling reasons. Then there's the might list, which is new. Some things got moved here. We're on just the regular list. Some of these are new, like hypertension. Now, I and others have been arguing that hypertension is an increased likelihood because there's all sorts of studies out there that say it is. So that, to that extent, it's at least helpful. Now we have something. But this is where, going forward, we may have some disputes. Besides COVID-19, right? Other grounds in that sort of other circumstances that we've been arguing and that some people at least have been having success on. Stack 924C sentences, right? The First Step Act changed the stacking rules. And so those clients that are serving Stack 924C sentences, you can argue that the disparity between what they're serving and what they would serve if they were convicted of the same offense today is an extraordinary and compelling reason. I know Kathy won one of those recently. I won one of those recently. Similar with 851 enhancements, right? The criteria for what constitutes, what could enhance a sentence under Section 851 for a drug trafficking crime has changed. So you can make that argument also. And then guidelines amendments or case law in particular, I've been leaning heavily on this. United States versus Havis last year, where the Sixth Circuit said that attempts and conspiracies, also in a follow-on case, are not attempted drug trafficking offenses are not career offender predicates. You can argue that they would have a lower guidelines range than today. Someone may not qualify as a career offender today that did at the time of sentencing. And I had one where we did get a compassionate release grant. I did cite that as a ground. The court didn't discuss it in the order, so I can't cite it as precedent, but I think it was probably at least helpful. But that case cited there, the Smith case out of the district court in DC, relied on those grounds. And then, yeah, anything else you can think of, right, that you think could be extraordinary and compelling. I cite this one, it was from Judge Nugent, it was last year. This is Nicholas Walker, who wrote Cherry, the book that the Russo brothers then turned into film, that was filmed here in town. And if you read, there's this, one of the factors he noted was this extraordinary job opportunity. That was actually to be an executive producer and consultant on the film. So, that's obviously unique, but if you can come up with anything else that makes your case stand out significantly, you can see that none of the other factors here fit into any of the established categories. So circling back again, we talked about procedural requirements. We went through extraordinary and compelling reasons. The next element that the statute and the guideline tells us is danger to the community and the 3553A analysis. So by statute, rehabilitation alone can't be an extraordinary and compelling reason. I cited that there. But it's still important, right? Because it fits into both of these factors. You can get, your client's progress report. You can show what programs they've done. You can show that they're not a danger in that way. And it's that post-sentencing conduct that you can use to argue that the 3553A analysis should be different now, right? In addition to rehabilitation, obviously you want to note any changes in the sentencing guidelines, even if the court doesn't think they constitute extraordinary and compelling reasons on their own, they might help in this analysis. And then everything else in a normal 3553A analysis, the things that have changed since the original sentencing, I think are particularly useful to highlight, right? Because you don't have to tell the court, hey, you were wrong last time. You have to tell them, look at all these things that are different and have changed the analysis. So age, family circumstances, medical conditions, right? Not just COVID related, but anything. And I've been using this a lot. I haven't had a court actually, cite it back to me, but prison conditions right now are both riskier for inmates' health, but are also more severe generally, right? They've cut off programming, they've cut off visitation, they're restricting movement. So, there's good case law out there generally that when someone serves time in a harsher prison, they don't need, like, deterrence and just punishment can be satisfied with a shorter sentence, a shorter prison term. So I've been using that a lot in my 3553A sections to just try to guide the court to say, look, they're spending now the last few months and at least the near future in a harsh prison environment. And, that's something you should take into account. And here's a structure, and we've got one left, which is the release plan. Kathy touched on this, and I left off a 50. BOP's program statement 5050.50 says that at a minimum, the inmate has to have a release plan that involves where they're going to be, how they'll support himself, how they'll support themselves, and if the basis for the release is medical treatment, how they're going to get it, both where they're going to get it from and how they're going to afford it, which might include a job, but it might also include Medicare or Medicaid or something like that. If you're going to ask for home confinement, you're going to want to tell the court, right, who they're staying with, where they're going to be staying, so that you can have the probation office check it out, and what they're going to be doing. If they've got a job lined up, that's obviously great, but anything else, if they're going to help take care of anybody, if they're going to be doing classes, just anything you can think of that supports the idea that this release is a good idea. Home confinement, Kathy talked about. They can't, the court can order home confinement as a condition of supervised release, right? But if you're going to ask for home confinement, it becomes more important to identify exactly where they'll be, exactly who else will be there, and exactly what they'll be doing. And those last two things, this is real tricky. I don't have any good answers. The government pretty regularly has been saying, if you release them court, you should order a 14-day quarantine before release. Sometimes you can say they've already been in quarantine. Otherwise, I'm not sure exactly what to say, other than if you can say, look, they've got a place to go on home confinement, they can quarantine separately in this separate room or in the basement, that kind of thing. It's worth putting in there. But otherwise, you may just be stuck with a couple weeks of extra time. And if it's COVID related, that's, again, I don't have a good answer for why they're not a risk to the community to bring the potential for infection rates out, except just to emphasize that it's worse to be in, and the spread in prison and the spread among staff and the spread of staff back to the community is a much bigger risk than release to home and then staying at home. So that's the structure, all four elements of that, and I'll pass it back to Kathy to take it from there.
Okay, so the next section we're just going to talk about, and this will go quickly, I think, because what do you do when you get a compassionate release case? These are the steps that we recommend. I mean, every case might present unique circumstances in which you just need to determine what the best avenue is. We first take a look at the PSR. Take a look at the PSR. Are there medical conditions or extraordinary and compelling reasons that might even be already contained in the PSR? Can you use that as evidence? You can check the PSR for, are there other issues like 924C stackings? Those sorts of things. You want to start pretty early on trying to reach out to the client. I mean, it's been, at least in my experience, I don't know about with Christian, the bulk of my time on these compassionate release cases is trying to reach out to the client and have those conversations, because they're all on lockdown at this point, or some form of lockdown. And so it's becoming really difficult to get through to the BOP and get a call set up. If you cannot get through to the switchboard, and that has been true on a few of these institutions where there's just nobody answering the phone anymore. I know Elkton is one of them. You might want to email the executive assistant that email address, again, that's at the front page of that particular institution, and say who the client is, what the BOP number is, and that you're trying to get a legal call scheduled. I've had the most amount of luck through that. If that doesn't work, your next option, I think, would be reaching out to the BOP Regional Council. It's just been difficult. So that's the thing that I sort of jump on right away. Even if I don't have already identified what the grounds might be, I start trying to reach the client. You're going to want to start as quickly as you can the exhaustion clock. So you're going to want to talk to your client find out, did they submit the request to the warden? If they did, what were the conditions that they put in there? All of those things that we've already talked about. If they haven't, you might either consider filing one for them or having them submit that request right away. So you want to get that 30-day clock starting, because you're going to have to wait that 30 days anyway. So then you've got 30 days to get sort of your ducks in a row about whether you want to file or what you want to file. You want to identify the possible grounds for compassionate release and then work to get the support for those documents or those claims. So if it's medical related, you're going to want to obtain the medical records. We'll talk here in the next slide just briefly about how we're able to obtain medical records from the BOP. We've got, I've had a lot of luck through the FOIA process. They've expedited, the BOP has expedited those responses, and I usually get them within 24 hours. With the documents that I'll show you. I always ask the client to send me a copy of the BOP progress report. In that progress report, it lists their disciplinary infraction for the last 6 months. It also lists all of the programs that they've completed. It also talks about when they might be released to halfway house or things that they've been doing good. Sometimes there's little like counselor notes in there. I have not had any luck. I don't know about Christian. I've not had any luck getting the BOP to send that directly to me. I think I've had that in one case. I usually have to get it from the client. So the client's got to ask the counselor or the case manager, and the case manager gives it to the client mails it to me. So you want to get on that pretty quickly too, so that you can get it within that 30 days. And then you need to help the client identify a release plan and work to obtain any necessary records. So if they're going to ask for home confinement, you might want a letter from the person who's going to let them live with them to explain what the situation is, that there's maybe nobody else there, that they can be socially distant if it's COVID related or health related. So you just have to sort of think through what's the release plan and what records do you need to substantiate that claim. And then just briefly, medical records. So you can get a copy from your client. The BOP is having, at least in some of the institutions, having a hard time responding to inmate requests for their own medical records timely. So that might not be an option. But if the client already has them or can get them quickly, it might be worthwhile just to get it from the client. The other is the Freedom of Information request. You would email this email address right here. In that, you need to include this certificate of identification. It needs to be completed. So the full name of requester would be the inmate's name. The current address would be whatever BOP institution he's at or she's at. Date of birth, place of birth, all of that would be in the PSR. The social security number, I just include the last 4. Then this is going to be your signature and the date. And then down here, I usually list, my name and my contact information. You want to email a filled out form there. You also an order of the court appointing you to the case, and then you email it with a request and detail what medical records you're looking at. And that's part of the conversation that you're going to have with the client. If the client says, I have, hypertension or obesity or whatever it is, you need to find out, are these medical records going to support this claim? If they are, get them. If the client's not sure, get them. If the client says, yeah, no, I haven't seen the doctor since I've been in the BOP, it might not be worth your time. So if you can't get it from FOIA, I don't know why you wouldn't, because like I said, they've been very quick on responding, but you can also email regional counsel. I've had that come through them once, and I copied the government because it was a client that had already filed in the court. And I couldn't get a response. So I emailed the regional counsel and copied the government. They did respond back in a few days with the records that I needed. Okay, and so I think I can figure out how to stop sharing. Was I sharing?
No, but I did for you.
Oh, I'm so sorry.
It's all right, we got it.
Oh, I'm sorry.
All right. So this is the last section we want to present then. Resources. my experience is that there's, the problem isn't that there's not enough out there. The problem is that there's too much out there and you have to find a way to sort through it all. So hopefully this is a targeted list, and it kind of expands as we go down. So we looked at the CDC website a little bit earlier. That's really good, obviously, for the risk factors, but also for general information. If there's anything you're wondering about treatment or recovery or things like that. BOP has their page about how they're doing operations. A lot of that is just press releases, right? And fluff. But they also have statistics on there that are broken down all the way down to facility level. Number of infections, number of deaths, number of recoveries, number of tests at each facility. Federal Defenders of New York has taken some of the BOP's numbers and graphed it out. That's nice to insert into a motion. FD.org has a pretty targeted, not too overwhelming set of orders and pleadings, and some publications with tips on how to handle things. Professor Berman's sentencing blog from Ohio State, he has regularly been compiling order lists, 20 compassionate release grants, most COVID-19 related over the last week. He's got maybe a dozen posts like that, which are useful for, just finding helpful case law. He also will post, news articles and things like that that are related. You can search on that site. FAM and NACDL have a volunteer portal with some training if you sign up for their volunteer compassionate release program. It's good to be aware of the lawsuits going on across the country. Elkton obviously produced a lot. The Judge Gwynn's order was eventually vacated, but there's a lot of useful information in the pleadings. There's a similar lawsuit at FCI Danbury that's ongoing. VOP staff has filed a class action. It's probably worth, if you check the facility a client's at and they've got even a relatively significant outbreak, it's probably worth just Googling the name of the facility with lawsuit or class action to see if there's something out there. And then some federal defender employees have been running an account with all sorts of useful information. And the information on the screen there is how to ask to be added to that account. That's contact for Kathy and I. I'll leave that up there just a moment, but we'll be able to send this out later. And that's our presentation. I don't see anything yet in the question and answer box. So now is the time, though, if there are questions that have come up. It's at the bottom of your screen, Q&A. If anybody wants to type anything in, we'll be able to see it and we can answer live in person. Any other thoughts, Kathy? Anything I missed?
No, nothing I can think of. So I'll take the second question. So the materials we'll send out, Chris Sason will send out the PowerPoint at the end when she gets the participant list. So this PowerPoint will be sent to you with all the links and everything in there.
All right, go ahead. Yeah, so Steve writes that we've gotten requests from chambers to reduce the length of our motions. And the thought being that we can cut back on some of the background law or boilerplate. Obviously there's at least potentially a concern that we could end up waiving arguments if we do that. But so, definitely do what you got to do to not waive any arguments that are important, right? But I do think there's something to that The judges have seen a lot of these now, especially from our office. And I would say two things about that. One, keeping it short is good. Two, though, the whole hook for all of these is extraordinary and compelling reasons, right? So this is the time to use your skills to make your client look different from everything that they're just seeing boilerplate. The pro se motions, they're seeing boilerplate. I do think it's important to get things out right up front. What is it about this case, right?
The next question is, other than reasons, the catch-all provision, are you arguing cases that do not have any significant medical justification for compassionate release? I think the 924C stacking falls under that. So I think that's where I think both Christian and I have had a little bit of success. I mean, those, especially some of those, they were pre-Booker, they're stacked 924Cs. The sentences were just outrageous. So the sentence that they would be facing today is half, if less than that. I think the one I got yesterday, I think knocked 30 years off of his sentence. It was ridiculous.
I had a mandatory 45 that he had served 23, and he was over both the mandatory and the guidelines now, right? It would have been a mandatory 15 plus guidelines.
Yeah. So I think that's the argument that I am aware of that's been most successful, that is not COVID related, it's not medical related.
Yeah, the next one is the most frequent argument we're seeing from the government to oppose the motion. For me, this is probably useful to hear from both of us, right? What I've seen in every one, I think, is they're a danger to the community. Mm-hmm. In every single case. I don't think I've had one where they say, yeah, this guy's not a danger. So even we talked about how even sometimes the government is conceding this could be an extraordinary and compelling reason because they've got a CDC recognized risk factor. They're still saying this person's a danger. And sometimes they don't say anything other than look at the offense conduct.
Well, and I think in mine, when I agree that every single one of them, it's look how dangerous they are. But they've also included the argument that we talked about before about they weren't eligible for home confinement under the CARES Act. So that's just proof that they're dangerous and shouldn't be released. Right. So that kind of gets thrown in there too, which is just, again, ridiculous because I had a client who was a pattern of recidivism of low, who was no danger, and that they made that argument was crazy. So I think you can flip that argument around on them and say the reason why they're denying it makes no friggin' sense. So yeah, I would say that's the most common.
You should take the next one. You're the expert on records.
So I guess the next question really just says this person's not having any records getting or having any luck getting records, even though they're following the requests. If it's medical related records that we're talking about, I don't know any other way to get them. So if you've submitted the FOIA request and that hasn't been answered, I'm not sure why. I would maybe submit another FOIA request. I would just make sure that the attorney is assigning the form, that you're attaching the order, and you're being specific about what records you're requesting. You could also copy or email the regional director and say, I've submitted this request, it's been pending. The only other option I can think of is the government can get these records lickety split. So in a case in which it's already been filed and there's a government attorney assigned, you can reach out to them and say, I've been asking for these, I can't get them. It's possible you could go to the court and ask for an order, but I really wouldn't try to go that route.
Yeah, I had one where I was appointed and I couldn't get a hold of the client for almost a month. Phone calls, emails, letter, nothing. And I finally reached out to the AUSA and said, one, can you help me get a hold of this person? They said no, but two, can you get me their medical records? And they got me their medical records the next day. And it turned out he'd been hospitalized for COVID, which is why they weren't getting back to me.
So the next question is, what is the recommended course with a client who has been sentenced but not reported yet with medical conditions? So, I mean, I think this is a word of caution for those who are getting ready to be sentenced. If they have some sort of concern, my strong recommendation would be to push that sentencing. I don't see why you would try to go forward right now with sentencing with somebody who has risk factors. The BOP is not doing any transfers. They're just going to sit there for a while anyway. Try to push that sentencing would be my first recommendation. If this, the question really is about somebody who's already been sentenced. So the question to that answer, I would say, ask for a deferment on report date. I think the court has the authority to push that out, and you can cite all the reasons, all the medical reasons and that sort of stuff. You can, I think, technically file a compassionate release, although if they were just recently sentenced, this was something that should have been contemplated by the court at the time. So I wouldn't recommend the compassionate release route, but understanding that certain cases may warrant that. So that would be my recommendation. I don't know, Chris, do you have any other?
No, I mean, we could riff on asking for a compassionate release. The first thing you're supposed to do is make a request to the warden. You don't have a warden yet. So I'm really not even sure how you get started.
Yeah, I mean, well, that depends, right? If they're in CCA or some institution like that, you could make the request there. But if they're out on bond, then you got all kinds of procedural problems.
Right.
Has there?
Go ahead.
No, go.
So the next question, has there been a final determination about whether a person is entitled to counsel on appeal if they've been denied? I don't think so. The Seventh Circuit weighed in on, at least raised questions about whether people are even entitled to counsel on these sort of thing. I'm not aware of anything in the Sixth Circuit. Are you?
I am not, but I will tell you, I think the way it technically works in our circuit is you're going to be, if you're filing the motion for compassionate release, you're in that case gets denied, you're still on the hook for the appeal unless you get permission to withdraw. So the issue in the Seventh Circuit became when the council received permission to withdraw, and then the court became concerned about whether they were entitled to counsel at all. So it's only going to become an issue about whether they're entitled to counsel is if a client gets off of the case. We have a blanket appointment in this district from the chief judge. So clients are going to get counsel if they want counsel on compassionate release motions in the district court. And then, like I said, you're stuck on the appeal unless you have permission to withdraw.
So the next one, the question is, client at a camp, low security, only a few COVID-19 cases, no pre-existing medical problems, had asked BOP for release. What's the best approach there? It's probably, I mean, honestly, it's probably to really, like, we would have to sit down and dig in, right, to that particular, like, dig through the PSR, dig through records, try to come up with something. On the basis of low security, not much COVID-19, and no pre-existing problems, I would say you don't have grounds on that. You're not going to get a release from that, but maybe there's something else that we're not thinking of.
Well, I like the low security because it's that's the argument that he's not a danger, right? Or she.
The BOP obviously decided that they're low enough of danger.
And there are cases that say just because there's no active COVID-19 outbreak at the institution, that doesn't mean they're not at risk. So I think you can find cases out there that say that.
Right.
They don't have to have existing medical conditions, but they've got to have something, right? So it can't just be the risk of COVID and nothing else. I think everybody's in agreement that that's true.
We've talked about this, right? It proves too much, right? Because what you'd basically be saying is let out everybody, and they're not going to do that. So we got to come up with something that makes this person unique. And I don't know what it is yet, but sit down and work on Have you filed for compassionate release based on family members' ill health? I did, but it was parents' ill health, and I lost pretty quickly. It didn't fit into category C because it wasn't a spouse or child, but I tried to say, well, it's this person's parents, they're an only child. They don't have anybody else to take care of them.
I have not filed on that basis.
Go ahead, next one.
So if the client is facing a mandatory minimum, can you argue compassionate release at sentencing? No.
I don't think so. I think, right, I think the court's stuck at sentencing.
Yeah.
But you can come back later, and let's put a big asterisk at later, right? To ask for compassionate release. And now come back to the asterisk. I don't know how much later it would be, right?
And it's got to be, I think that it's pretty clear, there's got to be something that wasn't contemplated at the time. That's why COVID-19 helps, because it was stuff that wasn't contemplated at the time of sentencing, in theory, right?
I disagree with that, actually. So the guideline says the extraordinary and compelling reason need not have been unforeseen at the time of sentencing. The guideline commentary says it could be something that everybody knew and anticipated, and it could still be extraordinary and compelling. So you could put those together and say, hey, at sentencing, you were stuck with a mandatory minimum. Now that it's a month later, look, COVID is an extraordinary and compelling reason to go below. I can imagine that there's a district judge out there that would agree with that. I'm not sure if they're in our district. But it's worth thinking about. I mean, the last one on the list, and it's 1 o'clock, so it should probably be our last question. How can we obtain a client's pattern score? Pattern being the BOP's risk assessment tool, right? Is this in their progress report? It's not in their progress report, right? I have gotten documents from clients that have their pattern score on it. I don't know what exactly they call that document or how they request it. Do you?
I don't know I have also seen it in documents. I don't know what they call it. I have asked the client to get me that information, is what I've done. And they go to their case manager and get it.
Yeah, so it's probably like you said with progress report. I've never been able to get somebody else to send it to me. In fact, if I talk to a case manager or a counselor about it, they say, well, I'll send it to you if the client says they want me to send it to you. That's the best I've gotten. So probably the same thing. If you think a pattern score would be helpful, you got to ask the client to get it for you.
I've really seen it in the denials for when the client submits the request to be released. They respond and say, no, you're denied because your pattern score is whatever.
Right.
So I've seen it there.
But if you're going to use it because it's helpful, it won't be in there.
Well, I don't know. The one I got
say,
was low. So, I mean.
Oh, really? Okay. All right. Yeah.
I mean, it wasn't hurtful for sure. So.
Okay. I think that's the end of our program. So thanks for everyone's attention. I think we can't see you, but yeah, appreciate the questions, and thanks for spending an hour with us on a Friday.
Take care, everybody.